continuing now with Digital Davos. And our next panel is about AI implications in patent. And Fred Douglas is one panelist here, and it's a fire chat around. So 1 second. Thank you very much. I now with Digital Davos. David. Not David, Fred. Sorry, you have to put the YouTube off because we have a callback from the YouTube. You're now live.
Yeah. Hi, Fred Douglas. I'm a patent attorney. I've been practicing patent law for about 20 years. I prepare patent applications and also I litigate patent disputes. Going to talk today on AI, its impact on the prior art, the falsita, and patentability. I wanted to show you that there are several unknowns out there in the patent world. Artificial intelligence is impacting all types of facets of the patent world, and we are not going to be able to do anything without trying our best to adjust for the artificial intelligence and also try to maximize its use the best we can. So applications are already out there and are being developed for AI-related applications. The autonomous electrical vehicles, they're working on harnessing AI systems to navigate complex road environments and make real-time decisions. For example, an animal or a human being darts across the street, or if a sinkhole develops in a road, the driving system has to adjust for that on a really no notice to ensure safe and efficient transportation. Medical industry, AI is used to improve diagnostics, drug discovery, patient care, and there's quite a bit of patents already being applied for, and also take care of the medical data, the patient records, imaging scans, and genomic information. Banks, financial industry, using the AI. According to The Economist, a 2022 survey of IT executives in banking found that 85% said that they have a clear strategy to adopt AI in the development of new products and services. So we have new products and services, inventions that are going to happen in the financial industry. And also the music industry. I'm sure we've heard about the false images and voices, for example, involving Drake and other artists and the tools that are assisting artists in the field. So there's a lot going on in artificial intelligence. So we're focusing today on patentability. One of the issues of patentability is, who is an inventor? An AI system, a computer, can it be an inventor? The answer, according to the appellate courts, is no. The Federal Circuit ruled in Thaler versus Vidal. There's an inventor named, last name Thaler. He keeps applying for an application. He names his AI system as an inventor, and he fails all the time. He's been litigating for years. He's litigating through all the different countries. He has been denied a patent every single time, except for one exception. He did get a patent in South Africa. But at least for here in the United States and most countries, he's not going to have any machine. Incidentally, for a patent inventor, has to be a natural person. A corporation is not an inventor. A country is not an inventor. A machine is not an inventor. It has to be a human being. Now, other aspects of artificial intelligence beyond the inventorship is the use in prior art. It's very useful at the time for searching for prior art or analyzing prior art if you want to determine whether your invention is patentable, or if you're in a litigation context and you want to attack or try to invalidate someone else's patent, you can use it for searching prior art. Now, there have been a lot of hallucinations that are known in the world of artificial intelligence. Hallucination is basically a false result. If you ask a AI system to do some research or produce a result for you, and the result is Um, it appears to be genuine, but you look into it and you find it's not true. There was a case, Mata versus Avianca, where a lawyer submitted a brief with three or more cases that he found through artificial intelligence. He input into the chat GPT the legal ruling that he wanted, and he thought that he could use those cases. He didn't look at the cases, he didn't review, he didn't verify them, and the judge caught him, and he was sanctioned, and he had to pay a lot of money, and he got a lot of embarrassment. And that's not the only instance that was widely reported in the news. There were quite a few other instances of lawyers trying to use artificial intelligence to do the research for them. So lawyers have to make sure that they verify the results, just like if they had a human assistant do research for them or do a patent search for them. The human assistant, you have to follow back and make sure that their results are correct. And the lawyer who submits the item to the court or the lawyer who submits the patent application to the patent office is responsible for the work product of the human assistant or the machine assistant. So, one of the things that we talk about is prior art. Prior art, you can find prior art quite easily with a Google patent search, the US Patent and Trademark Office search. You can also just use it for artificial intelligence with a chatbot. The advantage with a public prior art search regarding hallucinations is the hallucination is not that much of a problem because when you're trying to invalidate a patent, all you need is one, if not more, pieces of prior art that invalidate the invention. If you can find just one, you can look at it, review it, then your job is done. As opposed to a patentability search where you're searching for many, many patent applications to find out if the path has already been prepared, you can get hallucinations and you can have time wasted. So, one of the problems with the prior art is prior art usually is a document, a publicly available document. You can Google and find a PDF document. You can go to a library. You can find a book, a journal article. You can subscribe to databases and you can find articles for as whether a invention has been practiced before somewhere. But the prior art has to be publicly available and publicly accessible to count as prior art. Because basically, what you are saying, if you are using a piece of prior art against an invention, you're saying that hypothetically, somebody can go to a library in Indonesia, find a journal article on the shelf, freely pull it off the shelf, read the contents, and understand the invention that was published in that article. But if your prior art is in an AI chat service, is it really publicly available? There are different levels and different types of AI systems. There's Chat GPT, there's Google Gemini, there is Claude, and quite a few others. Some of these have different levels where there are subscription services. So the public may not be able to find that document. Also, when you get results from an AI service, they are not necessarily indexed or cataloged so that another individual can find the results. For example, let's say you invent a method, a new method where you're going to remove contaminants from wastewater. You input it into the Claude AI system. And using artificial intelligence, you develop a detailed new invention. If you leave that detailed recipe, that detailed invention on the servers of the Claude service. And if the Claude service uses the results to train the large language module, or if somebody in, let's say, Wyoming is a researcher in the same field and they are fed your invention when they do a similar search, is that a public disclosure? Is that a private disclosure? We don't have any rulings from the Patent Trademark Office or courts on such scenarios. We have to understand that the publicly accessible document is for people who are interested in that topic, and a key term is ordinarily skilled, and they find it with reasonable diligence. They can locate the reference. A person interested would be someone in the same field. So if I say that we're looking for how to remove contaminants from wastewater, any person on the street may Google and find something, but that's not a person ordinarily skilled. That's just an ordinary person with no specific skills. So somebody who is already working and educated and experienced in the field, would they find that document? Would they find it somewhere in artificial intelligence in a chat GPT um, session? I believe probably not. I do note that um, Claude and also Chat GPT 4.0, they offer the option that you can keep kind of private your results, and you can also have them not use your data, your documents for the language learning module to learn off of your data. That's what they claim. You should research the terms and services of any artificial intelligence service that you use. I do note that Claude and ChatGPT 4.0, they specifically say that they are not going to use your content to learn to use for other people. However, Gemini from Google and a few others, they're silent on that topic. And so you should assume if they're silent on a topic, you should be very aware.
Right?
Yes, sir.
One question to this. A public disclosure is not only about documents, but could be also basically when an item is already for sale, when an item is other way made available. My question is, would be the item not being already made available when AI is trained on it? Would this be a different, what is the difference between finding a document which has to be findable in the library, which accessible and so on, as long as it's in my research library down in the basement and only I have access, it's not public. But by sale or by when it's used already to train an AI, is it not the same thing than I sell already a product? Because when I sell a computer chip, there is there is a lot of work done to look how the computer chip functions. We all know this is just a phone. I mean, we don't open and see really what makes a phone ticking inside. My
Yeah.
question is this a problem with AI?
Yes. There's another grounds for invalidating a patent or having your applied application be rejected, not only if it's publicly available, but as you put in your example, is if it's being already sold more than a year before the application date. So just thinking off the top of my head, the hypothetical you propose, if the invention is already sold and it's sold publicly and the AI already has it, and if somebody uses an AI system and they, for example, they put in a query, what is the best method or the best machine for removing wastewater contaminants. And if they find it through, let's say, Google Gemini, they find it and they find an indicator that's already sold, if the system points them to where they can buy it, then that's proof that it's already for sale. And that could be harmful for the um, planned patent application, because you're not going to be able to get a patent, or your issue patent will be invalidated with the evidence. So the evidence from AI might be quite dangerous there. So what you're saying right there is basically another concern is, what if artificial intelligence generates prior art? If I enter into an AI system a question, how could I remove wastewater contaminants? If artificial intelligence creates the solution, I don't create the solution, but the magic computer creates it, we have the issue of non-human inventor, but also the prior art is generated. So if that recipe or solution or that machine is revealed to me, and if it is allowed to be used by the public and they train on it, or if I keep it on my own laptop and I don't publicize it, but it's still been around, somebody might be able to use that as proof at a later time. If I share the artificial intelligence account with another employee or somebody, a business partner, they might steal my invention. That's another concern. But one of the issues we have with artificial intelligence is also, you heard me earlier say, ordinary skill. The patent office and the patent courts look for PHOSITA. I pronounce it Fosita, but we usually just call it by its commonly long name, person holding ordinary skill in the art. So somebody who is experienced and knowledgeable and educated in the art. For example, removal of contaminants in wastewater. So if somebody who is an engineer for a civil engineer for a wastewater treatment plant, if they know of the general design, description, or a recipe for removing wastewater, but what if they input a query into Chat GPT, Google Gemini, or Claude, or any other system? If the output provides a solution or illustrates generally how to do it, the patent office right now is seeking public comment on whether the person holding ordinary skill in the art can be represented by an artificial intelligence system. So another example is, let's say I have a patent that's on a method for removing wastewater contaminants, and I have somebody who is in litigation and trying to invalidate my patent. They might want to try to show that my invention is obvious. Obvious is where there is no exact disclosure of your invention, but anybody who is a person holding ordinary skill in the art could figure it out without undue experimentation. So if the person who's suing me to invalidate my patent runs a AI bot with the problem, and if they can come out easily with the same invention, so the problem I have is I have to convince the court that the AI system is not a person holding ordinary skill in the art, because my opponent in litigation is going to be saying, hey, all I did was a fancy Google search, Google Gemini. I found a computer who could generate the same invention. So it's not really that big of an invention. In Europe, they call it an inventive step. And here we call it obviousness, where the step between your starting place and your invention is something that anybody could have done easily without too much thought. That is a big issue that the Patent and Trademark Office is seeking public comment on at this time. Now, like I said, also, the other concern is whether the AI service retains that and trains the LLM and produces the output and it produces to others. But also, there's another issue with your patent. As quite a few people know, you cannot patent a perpetual motion machine. The patent office has ruled it's totally impossible. But then the hypothetical is, what if AI solves that issue and creates a perpetual motion machine? What do we do? The invention to be patentable has to be operable. It has to work. Most patent applications are submitted on paper, so you can't really physically prove that they work, but a person holding ordinary skill in the art should be able to review the design and conclude that it will operate if a physical embodiment was made. But the presumption is when you have a patent, it's presumed to be operable. And it's also another patent lingo term is enablement. Enablement is your invention is like a recipe or how to instructions. Your patent must give the recipe or the instructions to a person holding ordinary skill in the art, FOSITA, so they can copy your invention when your patent expires. But if that person with ordinary skill cannot duplicate your results because your patent application did not give enough information, then it's not enabled and it's invalid and you don't deserve a patent. The presumption is there. If a patent is issued, it's presumed that it's enabled, presumed that it's operable, and it's an uphill battle for your opponent to convince a court or convince a patent office that it indeed is not operable and not um, enabled. However, if the AI system can generate the same result, does that mean it's really enabled? Is it really operating? Because we have hallucinations. If I tell Claude, produce for me a perpetual motion machine and explain to me how it is enabled, I get the results, I run to the patent office, and I tell the patent examiner, this is a perpetual machine. Do not tell me it doesn't work because the AI system showed me how it works. But that's not a person holding ordinary skill in the art. It's a computer, maybe making a hallucination. That will be something that people will probably worry about. Just to restate on obviousness, that's when you have a claimed invention where the differences between the claimed invention and the prior art are such that, on the whole, anybody at the effective filing date of the claimed invention with ordinary skill, could that person create the same invention? And the key thing that a lot of people gloss over regarding obviousness, and it's key here for artificial intelligence, you have to prove if something is obvious, you have to measure time regarding the effective filing date of the claimed invention. So if I file a patent application in 1999, well, my patent is obvious or not depends upon going back in time at 1999. Would a person holding ordinary skill have the knowledge, experience, and education to duplicate my results? But consumer oriented artificial intelligence systems were not available in 1999. So if I run a query today in 2024, and if I create the same invention, that's not good enough. And that's a difficulty we're going to have in litigating patents is the Wayback Machine is not good enough, and the artificial intelligence system were not really developed and widely available at previous time. So trying to invalidate a patent for obviousness at this point is not going to be very useful, but we should take a note of that for the future. So there's a lot of unresolved questions that the patent office is seeking comments on, and also the litigation-based attorneys are also hoping to state that it's a new frontier with the assistance of artificial intelligence in the patentability of patents. One question is, how do AI-based tools determine who is a person holding ordinary skill? What is their knowledge? What is their level of skill? I don't think that current consumer-oriented systems take that into account. Who is the hypothetical civil engineer, wastewater engineer? Who is the hypothetical uh, pharmacist who would understand a new drug discovery? Another question is, we interpret claim terms. We have certain lingo. We have terms that everybody understands, shop talk, but does the artificial intelligence robot understand claim terms like a human being experience? Probably not. Also, the training data that the service uses, when was it acquired? You're trying to prove obviousness, which depends on time. You're trying to prove whether a sale was made at a certain time before a certain date, whether a public disclosure was made before a certain date. But we don't know, as ordinary consumers using artificial intelligence systems, when was the training data acquired and when was it compilated? And how do we determine enablement with a robot who didn't really invent anything? We can ask an expert in the field. In litigation, we can use a wastewater engineer to give an opinion whether this method was easily invented or was it something that nobody had ever heard about before. But yes,
a question here.
yes.
When we see, for example, ChatGPT, the language system, they most of the prediction is just like a statistical prediction, what would become next. So the problem right now is that some of the AI systems, or most of them, is missing the innovative step, the creation of association from two non-correlated things, which nobody thought about it, to combine. When it's combined just by pure mere statistic, would this not bring it up to the lower level? Then it's surely obvious instead of it maybe not.
I understand what you're saying. You're saying that the AI systems, I think you're saying, please correct me if I'm misunderstanding. You're saying that the AI doesn't really combine two different inventions or two different technologies that are superficially not related. Is that what you're saying?
Yes. And it's a mere statistic how it would be normally combined. So with this in mind, would it not bring the AI standard, if AI comes up with a prior art, it to the lower level and say, then it's surely by a professional? Because also ChatGPT right now says that they hope that AI will be as accurate as a PhD level in the next release. So right now we are before PhD level. So what is the level what a person needs to be on to a patent and so on? Please.
Yeah, that's the open question that we have, and the patent office is trying to get a grasp on, because if the system later is developed for, like you say, the PhD level, is that a person holding ordinary skill in the art? And how do we determine that? How do we measure that? And for example, if ChatGPT does that, but Gemini doesn't do that, then it depends quite a bit. But I still think, as far as what your scenario was, combining two different technologies that people didn't think about, I think quite often a person having a PhD who goes deep in one particular field not necessarily could be expected to be creative to pull in another technological field that they probably are not experienced or knowledgeable in, and combining that to create an invention. But I think one of the disadvantages we have with artificial intelligence, um, a previous panel was referring to movies, and they're saying that the AI generated video of a former star lacks a soul. I think very important in the patent world, the AI system, the computer, also lacks a soul, or lacks what I call creativity. You can have all the knowledge and you can train as much as you want with millions and millions and millions of pages of documents, but the creativity to take one technology and borrow something from another technology and meld them together and make them work, I believe still artificial intelligence is not at the level to do those light bulbs on the top of the head, those creativity, those innovative aspects. Right now, artificial intelligence is really more of fast plagiarism. They take something that's already there, they already trained it in, they've have access to all the knowledge in the world, but they don't have anything new. They don't have the ability or the desire to combine things.
But as an inventor, I run often in a problem in to describe the invention, and people don't understand it.
Right.
So you had to find tricks because you needed investors. So how do you explain it the quickest? And by explaining it, I found the quickest way is the way through questions. So you lead them, you lead them to the invention by making logical questions. And they answer the question, and you ask the next one, the next one, the next one. And I don't want even to use this word, which now comes, then they understand it. I don't want to say then it's obvious for them, because you had to lead them with question to question.
Yeah, don't use the word obvious.
We don't want to use the word obvious.
It's clear.
This
It's
is a
clear to them.
pattern killer, but
Right.
you have to lead them with question. So
Yeah.
as AI is led from question, from the input by the person using the AI. So AI, I mean, most of us know that sometimes you try to trick AI to say something which it shouldn't say, just like you are playing around. So, or you get an answer that this cannot be answered because of restriction, but it should be answered because it's academic research. So you have to find ways around to enable the AI to do the research. You cannot say to a human like, okay, no, look, I really don't want to make a nuclear bomb. I just have to know how it's done. And then the human says, you need it for this. Okay, I explain you. So AI, sometimes when you ask them to do something, it blocks us because of ethical guidelines, and you find ways with the question around. Now my question is, with obviousness, is because you guide it with question. Is it then really obvious when AI comes to the right conclusion? When I guide it with question to the answer? Because with questions, whole universities teach only with questions to find the answer.
Yeah, what you're describing right there is a good
Fred, you're
example.
frozen, I think, somehow in the video. Can you just move a little bit
Oh, yeah,
quicker?
I'm sorry. Let me try moving that.
Okay.
Okay.
Now you
Yeah,
move
now
again.
I'm here, right?
Yeah. Now you move. You
Okay.
were total.
Sorry about that. So what you're describing there, the questions, as I'm sure you know, and quite a few people know about the consumer-based AI systems, we talked about queries, but you don't need to input just one query. You can put a sequence and series of queries. And like you're referring to, trying to lead the investors so they can understand the invention. At the same way, in the litigation context, if you wanted to demonstrate that a AI chatbot can duplicate an invention, you can create a very um, smart sequence of queries to lead them down the road that you want them to go to,
Yes.
and try to show that their invention has already been done before, or that it's not operable, or it's not enabled, or if it's obvious. You can do
Yeah.
that. It's a technique I'm sure that a lot of patent litigators will try to do. And even if the artificial intelligence results are not allowed to be used in a trial, that can be a script for a deposition testimony of an expert, where the expert just duplicates the responses that were generated by the artificial intelligence. So that is something that could be done. I wanted to circle back a second for hallucinations. A lot of the issues with artificial intelligence and patentability are hypothetical situations that a court has not addressed, but someday they might. We talked about a lawyer who was using a AI chatbot to do legal research, and they got false results, hallucinations. Well, what if I'm an inventor and I'm trying to create a process for taking contaminants out of wastewater? And if I ask AI chatbot, let's say Claude, make me such a service, such a method. And what if it gives me a hallucination? So if I don't look into it, it looks like it might work, but then an engineer looks at it later and says, "Nah, that won't work. The AI computer just gave you something that was fake." But here's the problem: if I can get a patent application issued on that, where the human says it won't work, and then um, Chat GPT says it will work, if the examiner doesn't catch it, or if I can convince the examiner otherwise, I can have an inoperable, not enabled, maybe even an obvious invention patented, thanks to the happy circumstance of a hallucination. And then what do we do? And here's the one thing that really helps to defend against a claim of unobviousness. If your invention is totally unexpected, that everybody in the world said it can't be done, and if you got it to be done, or the synergy from two different technologies, that is one factor leaning towards it not being obvious. So somebody somewhere in the future is going to have a patent, and they're going to argue whether it's obvious or not. And if it came through a roll of the dice from some $20 a month chat GPT results, there might be something out there that somebody's going to sue someone, or maybe they might actually invent something that's very useful, and the AI technically would be the inventor. And then if you do succeed in defending it as being useful, but then they get you for saying the AI invented it, not you. So
Um, I,
that's a
I
big,
just
big
want to
issue.
refer here to one thing.
Yes.
The humans being are so resistant against change. And when you just
Yes.
say like the people would not like basically with if you have something invented which everyone didn't invent before and doesn't see it your way, and the AI would be the problem. I think in this moment the humans will be the problem. See Galileo. the world is around and moves around the sun.
Right.
No, it doesn't.
Copernicus
You
too.
can bring all the
Yeah.
arguments, then
Right.
it stops.
Right.
So I think there we will have a lot of human problems.
Yes.
So this gets me to a question, and then please go ahead with it.
Mhm.
Do you think that AI could be a fairer judge than a human? Because the bias is out, the human bias,
Well,
jealousy,
I assume you're
religion.
referring to a judge as somebody who rules on legal cases.
I for as an expert for seeing if it's obvious or not.
Okay.
Because it goes straight after the Bronx. This is fulfilled. It can be like this. During by humans, we have emotions in. I don't like. He looks like my uncle, which I never liked, or something like that. And I loved my uncle. Sorry, this I
Mhm.
have to say.
Yes.
He was
Yes.
my hero.
Right.
Sorry, like this was an
Mhm.
example. Or
Right.
he is or it's something which reminds something and something bad, or it's mad jealousy, which is in the scientific world really huge when people work years and decades on a problem and somebody beats them from 5 days to do something, or when some person want to implement something and it blocks $1 million of development. So the experts are not really neutral, and we see it like in litigation. Each party has an expert, and when they really would be experts which are fair and just, they would come to similar results. But we see also in damages. One says like damages is like 10 cents, and the other one says it's 10%. The other one is no, it's 80%. So it's like so far apart.
Yeah. I could see off the top of my head some advantages because the artificial intelligence uses logic. They use the data in front of them and they come with a result. And you do have the human negative jealousies or biases are not there. However, one thing you should note that there are already reports out there that a lot of these AI systems are discriminatory, for example, against women. They're sexist because even though you have a machine, the human beings designed them and programmed them. So you still will have that problem. We've had AI results. Um, we had somebody once, it was in the news, they were depressed, and the AI told them, well, go jump off a bridge. So that might sound like a human thing,
Yeah,
but the
I know
a
you refer
logical computer, you know.
you refer there to the tape bot, which was trained on data which were a catastrophe, and they had to be deactivated after 24 hours. So
Yes,
it was one of the best examples.
right. But going back to your original question about the experts, there are several problems with experts, the human experts, that I see might be beneficial of using a computer expert. The computer artificial intelligence would have access to everything that the human expert already has read, plus more. The the computer will have access to foreign language materials that the human expert probably doesn't even know that language. But human experts, we have problems. Usually in litigation, one expert says A, and the other expert who gets paid from the other side says not A. So you have two experts who are experts and knowledgeable, but the monetary aspect, they're naturally are going to say something that is good for whoever is paying them. You also have the instance if you have a special expert that is appointed by the judge. So the expert who's appointed by the judge wants to be appointed in future cases. So there's going to be a bias there to help the judge out in a certain way. Also, the expert might be in a situation where one side has um, an ordinary law firm and the other side has a big mega law firm, well, that expert, that testifying witness, would sure love to get future work from the big law firm who most likely would have more work for them, where the computer doesn't care about that. The computer doesn't have a daughter who needs a summer job clerking with a judge, for example. So I can see um, a lot of these human biases could be avoided, but still, everybody's going to fight over. They're going to want to see the source code of the AI chatbot, and also people are going to try to make efforts to prefer an AI system that's beneficial to them as opposed to their opponent. So those can be quite a few problems. So another thing is we're referring to my example. You can go to a library in Indonesia, pull a book off the shelf, and you can find the invention described there. That's publicly available. So a um, patent was done before it's not valid, or it could be obvious because it's publicly accessible. Yes, you got to go physically to Indonesia to get it, but it's accessible. Now, if it's on Chat GPT, it is publicly accessible, but now we have to look at the person holding ordinary skill. Would they find that document or that information or that sale in Chat GPT? And one of the unanswered questions we have is there's so much volume of material available in the language learning model and AI based tools. It's enormous, unwieldy. So, could an ordinary wastewater engineer find my method through all of the data there? Maybe, maybe not. And how to determine that and how to confine that is going to be quite a bit of an issue. Now, also, we have the issue of for security reasons, confidentiality, or for special uses, people are using artificial intelligence that is not on a consumer level. They have it made for themselves in house. A lot of law firms are creating artificial intelligence chatbots for internal use only. So, is a special AI system that's used only by a large law firm with offices throughout the world, is that widely publicly available or not? We'll have to think about how the patent office is going to deal with that. Also, there's an issue of reasonable experimentation for patent being obvious. If you can read my patent, but you cannot duplicate the results, it's still not obvious if you can reasonably experiment and take my disclosure and end up with the final method. But reasonable experimentation, if you can get it done by AI now, today in 2024, then the definition of reasonable experimentation, like a drug discovery, might not be so easy at this time. So, for example, if we have a bird flu epidemic and somebody wants to do drug discovery to find a cure for the upcoming bird flu epidemic, before AI, they could use, computers, and they could do a lot of experimentation, a lot of animal trials and human trials to try to come up with a miracle drug that would cure that pandemic virus, for example. But now with artificial intelligence, you could probably do it at a lightning speed. So the level of what we call reasonable experimentation or undue experimentation, because of the heavy use of artificial intelligence, might change. And what used to be considered not obvious before, finding that drug overnight or in a week, could really level the field as far as whether something is obvious or not obvious. Now, after a patent claim is written, what if you can take an AI-based tool and request it to combine with two or more pieces of prior art and duplicate the claim? So one of the hallmarks of obviousness is you take one document and two or more other documents, sorry, one or more other documents, and you combine them together, and could you come up with an invention? And a human being would usually do that. They would read one patent, read a different patent, and those two patents don't mention each other, but they put them together and they come up with your invention. But now with an AI based tool, you can go ahead and just say, here's patent A, here's patent B, give me claims that combine the disclosure in both of those. And so the question is, will that be useful in patent litigation to invalidate a patent by showing it's so simple that a computer-based AI tool can combine two disclosures and come up with the same invention? If that's true, then maybe your patent is not obvious, obvious, and your patent is killed. But one of the other things, the how sausage is made in the patent world and patent litigation. My example right there of taking document A, document B, combining it and creating a new invention. We have human beings. They're going to do that and they're going to file a patent application, but they're not using AI, but they're not going to reveal to the patent and trademark office that they created it with artificial intelligence, because they know having a machine as an inventor is not permitted. Having an obvious invention is not permitted. And also, we have for forever and ever, people hide prior art. They do not produce prior art. So those type of people are going to be expected to not disclose their artificial intelligence use. Now, right now, the U.S. Patent and Trademark Office requires people to volunteer if they use artificial intelligence to invent or prepare the patent application. And also, they are required to volunteer on the honor system if they use artificial intelligence in preparing the application in any way, and also to tell the patent office what results they got. But I doubt that there'll be many people volunteering that. I expect a lot of people will do that, and it's very simple. They don't need to tell the patent attorney that they did it. They can just bring the results to the patent attorney. The patent attorney just follows the procedure, files the patent application, and nobody knows one way or the other. So there are quite a few unknowns regarding AI assisted inventions and AI assisted applications. It's going to be litigated many different facets, more than I even mentioned. It's going to be litigated. People are going to use it, and discovery, when inventors are going to have to defend their applications, and they're going to be asked about AI. Any lawyer trying to fight patent litigation is going to ask them under oath when they use AI. And then they're going to find a fellow employee, uh, a business partner who um, doesn't like the inventor anymore and has motivation to hurt them. They're going to find out somewhere a trail of AI.
So we are going close to the end.
Yeah.
I have one question regarding this. So
Yes.
when we look at the economics of patent litigation, AI will cut down a lot of times on expensive lawyers and experts and so on, just by assisting drafting a patent. It will also help with accuracy in writing the patent, make something more eloquent to read and so on when used right. But how you say it is also the usage of AI will be a lot of things where there will be depositions about it, motion praxis, and so on. Now, is the uprise of AI used in patents, making filing filing patents or defending patents? The filing and the defending process more expensive or less expensive? Seeing the cost savings in several aspects by drafting the patent application and drafting the motions versus the increased motion praxis, which will be surely following regarding AI. So will it be a wash, or will it be driving the cost of litigation out?
Well, let me cut to the conclusion and go back. Conclusion is lawyers are going to find a way to make sure they get a bill to their clients, and it is going to cost more one way or the other. It's just going to. That's the nature of the humans who do the litigation and the humans who do the patent prosecution. So let's back up a little bit. One concern that I have is the ability to take large amounts of data and churn out large amounts of data. So there are Fortune 500 companies who are going to create patents and patent applications. They're going to pay to try to invalidate a patent $100,000 for a human being to do a patent search to get a gigantic stack of patent prior art. Now, anybody, Joe Sixpack, can use ChatGPT or other consumer-based systems for the for free or their $20 a month subscription, and they could churn out tons and tons and tons of prior art, and there'll be hallucinations in there, and there'll be real legitimate prior art. So when they file their patent application with the patent office, they're going to have a gigantic stack of prior art that they give to the patent office. They flood the patent office. The patent office is not going to be able to read every single item, but it's there. And now, if they are accused of hiding prior art, they're going to say, no, it's right there. I gave them 6,000 pieces of prior art. So I was honest, but we don't know if it's relevant. We don't know if it's um, hallucinations. And a litigation aspect, if you're trying to defend your patent, your opponent is going to give you 6,000 pieces of prior art that they got in 4 minutes off ChatGPT. And you have to go through all that, separate it out. And of course, you're going to use artificial intelligence to separate that out. And you're going to be hit with hallucinations over the hallucinations, and they might miss something that is good. So you're going to have to follow up with human beings at some point, and the amount of prior art that's thrown at you is um, going to be terrible. The discovery, if right now litigants before AI, they want to have every single document that you reviewed to prepare the patent application. Well, if they're on the receiving end of your discovery, they're going to flood you with tons of stuff they can create at the last minute and tell you it's already was in the file. And other way around, if you have to receive all that prior art, how are you going to go through that and determine whether you should settle the case today or fight more? So if there's a smokescreen involved, then unfortunately, the litigants don't get to talk turkey and see where the chips lay, because it's a smokescreen of prior art and documents and source code going there. So I see tons of abuse that could happen there, and I see tons of ways that lawyers can make money, and the system can get bogged down if we don't develop rules and guidelines in litigation, the court rules, the practices, and also the patent office, because the patent office has 6,000 pieces of prior art. What are they going to do with that? Do they ignore it, or do they review everything? So I think The abuses have to be understood, and there have to be appropriate rules formed. Right now, all we have is a lot of question marks, and we have to look forward to try to um, make these issues manageable. That's what I see.
Yeah. Okay. So this, I mean, is a theme. This subject can be discussed for hours and hours,
Yeah,
and it is interesting. And of course, as a new technology, every discussion lets us at the end with more questions than answers.
that
So
is true. That's true.
thank you for contributing to the world of questioning.
Well, it's my pleasure, and I look forward in the future we have some type of rules from the patent office and courts, and we can help people to understand the new rules as they come aboard.
Thank you very much.